You saw him tear up here on the stand when he's talking about the fear to his kids, right?
Those were actor's tears. He was acting.
And you sat right there, right?
And I laughed because it was a poor performance for an actor.
You laughed.
I could not help it. When you see a laughable performance by an actor,
I would like to just excuse juror number 5. And then we would seek the first alternate. Otherwise, we have to take tomorrow off. Any objection from the state?
No.
Okay, any objection from the defense?
That's fine.
Okay, and so you can excuse.
Yes, ma'am.
I figured we'd be done, but excuse juror number 5.
I certainly hope I'm not done,
Done with what?
or even overdone.
Okay.
You know what I'm saying, Judge? Oh, yeah.
Honorable Michelle Leavitt presiding. Come to order, be seated, please.
Okay, Mr. Blandino, you can take the stand.
Your Honor, sorry,
Swear in again.
I did forget here. Blandino, I want to bring it to Your Honor's attention that in previous entries here to the RJC during the trial, when he goes through security, he has to lift up his pant leg to show that he's on the electronic monitoring. He did not have to do that today, and is concerned that there's possible prejudice to any jurors that would have seen that. And he knows some jurors saw it, so that would be unduly prejudicial, showing that he is on pretrial. He's on pretrial detention and is a bad guy, as he says. I don't know which jurors to whom he's referring to, if he has any specific numbers of the jurors that he saw, but he's asked me to bring that to Your Honor's attention. Today, he did not. I guess they made the exception.
I insisted that after discussing it, they didn't have to show that. I insisted they take me, and they were able to accommodate that. So that's a failure administratively on their part to know.
All right, so apparently today they did accommodate. He asked him not to have to lift his pant leg, and they accommodated him today. So like I said, I don't know which specific jurors he's saying that he knows that saw that, but that's.
Is he indicating any specific jurors, Your Honor?
To my recollection on then, because we're talking about last week and all, I'd have to see their faces in order to indicate, but I can indicate.
Juror number.
Yeah, the juror numbers. Where the
We
juror
got
numbers?
1, 2.
Yeah, I got the juror number list here. Now, the one is.
Are you asking the court to do anything? Or are you just?
I'm bringing this to Your Honor's attention. I am not. I don't have enough. If you can't identify which juror,
No,
I'm gonna ask.
if you give me the
Please
list.
let him talk. Please let Mr.
All right.
Bateman talk.
I'll bring that to Your Honor's attention. That potential issue exists. Without knowing which juror, I'm not going to ask for this trial. I just don't think it's proper. Not
All right, so Mr. Blandino, if you'll take the stand, and Officer Hawks, you can bring the panel in.
Yes, ma'am.
Any first ask questions later, Judge.
At this time, you're going to become juror number 5. You can still stay there where you are right now, or you can sit in seat number 5. It's up to you. But I just want to make sure you understand that you are now juror number 5. Okay, does the state stipulate to the presence of the panel?
We do, Your Honor.
Is now impaneled? Mr. Dickerson?
We do, Your Honor.
Okay, Mr. Bateman?
Yes, Your Honor.
Okay, Mr. Blandino, you understand you are still under the same obligation to tell the truth?
Absolutely.
And you understand your testimony is being given under the pains and penalties of perjury?
Yes.
Okay, thank you. Dickerson.
Thank you so much, Your Honor. Mr. Blandino, how are you doing today, sir?
Fine,
Fantastic.
can't complain except the state and federal courts and commissions on judicial discipline.
I'm sorry, what?
I said can't complain except for state and federal courts and commissions on judicial discipline.
You can't complain?
Yeah, except for that. I can't complain about my personal, how I'm feeling and everything, yeah.
Oh,
Well, I
so
feel healthy. Yeah.
the only things that you have issues with are the state courts? Is that right?
It was a humorous thing. It was-
I'm just confirming what you're saying.
Yeah,
The state courts? You have an
Why?
issue with?
yeah, I have some complaints there, yes.
Okay, the Nevada Commission on Judicial Discipline, you have an issue with?
Yes, actually, yes. And the judges that I complained to about that, yeah.
And the federal courts?
Right, I've got a complaint pending in the federal court.
Well, other than that, you're all good, right?
Well, yeah, mostly.
Okay, just wanted to.
Thanks for asking.
Yeah, no problem. So, where we left off yesterday was looking at State's Exhibit 7. This is the letter that you sent Mr. Federico on May 9th.
That's a copy of that letter.
Copy of that letter, right?
Let's be accurate.
Right, 2019, right?
Right.
And what we were indicating as we went through this letter yesterday is that you had given Mr. Federico until Monday, May 15, 2019, or else you were going to be reaching out to his firm.
No, it doesn't say that or else. I don't think you're reading that properly.
Okay. So,
Did you actually see it or else there?
therefore, consistent with my beliefs, I will send a copy of all relevant documents
Right.
to the Olson, Cannon, Gormley, Angulo, and Staberski, unless I hear from you by Monday, May 15, 2019.
Unless is an or else though. Are you seeing that unless is the same as or else?
That's what you said though, right?
No, that's what I wrote.
Okay. And attached to that particular letter, you included some exhibits, right?
Yes.
And this would be Exhibit 1F, as you
Right.
titled it.
Yes.
This right here, you included what appears to be United States Court of Appeals for the Ninth Circuit case involving Kim Blandino versus Douglas Herndon in his capacity as the state of Nevada judge.
Mhm.
Is that right?
Yes. And in his individual capacity, to keep reading here.
As
And then
well as-
Jeffrey Weinberger, doctor.
Okay, great. And so with that, you also included an amended order from the same case.
Exactly.
Okay. And you included those because you wanted to make sure that Mr. Federico saw them.
Well, I thought it might be helpful to him.
Just to know what you can do, right?
Know what I could do? No, I wanted to know what I had done. I mean, that's what I had done.
Because you're a serious person.
Well, actually, I'm pretty comedic. A lot of people find me very funny.
Okay, but you're serious here.
Well, yeah, but my thing has always been if you're not having fun, you're not doing it right. And if you're not doing right, you're not having fun.
Let's talk about that.
Yeah. Happy to.
All of this was fun to you.
All of this, what is this?
Everything that you talked about doing with Mr. Federico, you had fun doing it.
I have fun no matter what I'm doing. If I'm being tortured, I can have fun. I was tortured
fact,
at Lakes
you're-
Crossing and I had fun.
You're having fun right now
Yes,
because you enjoy
because
it.
if you're not having fun, you're not doing it right, and if you're not doing right, you're not having fun. I've stated that specifically. Every marshal in this building just about knows that. It's my
Okay.
catchphrase, but it's true.
So ultimately, May 15th comes and goes, right?
It comes and it goes?
May 15th,
Every day
2019
comes and
goes, and you
Oh, you
don't,
mean in reference to the letter I wrote?
that's correct.
In other words, May 15th ticks off, and May 16th is the very next day. Is that what you mean?
Exactly,
I see.
and that happens.
Okay,
That's correct,
okay.
right?
Yeah, that's how time works.
And you didn't hear from Mr. Federico.
No, I didn't.
And so on May 16th,
I mean, to my knowledge, I didn't. Let's put it that way.
right. So then on May 16th, 2019, you made good on your threat.
Could you describe what you meant by made good and then what you mean by threat?
So I'm asking the questions, but I'll do that for you.
Oh, that's
I'll
nice.
show you here, State's
Mr.
Exhibit,
Blandino.
Oh, I'm
State's
sorry.
Exhibit
Yeah,
8.
I mean, you need to cut the commentary out and just answer the questions from the district attorney, okay? Thank you.
State's Exhibit 8, you see this right here?
Yes.
This is May 16th, 2019 at 11:39 a.m., an email that you sent, isn't that right?
No, it's not actually true. I can't answer yes to that because at the top of this, I don't have anything to do with this top above that, the lighter line. You got the heavy line right above that says Michael Federico. I have nothing to do with that. That's not me.
Sure, right below that.
And then when it says from Michael Federico, sent May 16th, let's see, is that from my email chain? I don't know if that is or if he added that.
May 16th, 2019, you sent a letter to Mr. Federico's law firm, correct?
I sent an email,
With an attachment.
yeah, but an email's not the same as a letter.
Well, we can get to the letter. So you sent this email right here, May 16th, 2019, 11:39 a.m.
Right,
Okay, that's your email,
that's my name right there you're pointing to.
right? Kim Blandino's your name.
What's, I never mailed to? My email is after the, is that a colon or semicolon? Now, my email is after that colon or semicolon. I can't make it out on the screen.
Got it,
If I could look at the original, I could see if that was a colon or semicolon.
got it. You want me to zoom in for you?
Yeah, let's do that.
Let's do
Because I
that.
mailed to, is that how my email goes? I don't know. So that's, yeah, mail to, and then colon, and then that's my email continuing on. @earthlink.net.
Okay, so you sent this email to Jim Olson, Walt Cannon, John Gormley, Peter Angulo, Mike Seversky, and Michael Federico.
Right,
You titled the subject line Proposed Settlement Issues.
yes,
You said, please see 3 attachments for review, correct?
yes,
You
that's true.
included your name and your phone number,
Right, yes.
same phone number that you've used everywhere.
Yeah, I've had it for a long time.
Okay. You turn the page, we have your attachments that you sent to the firm, Olson, Cannon, Gormley, Angulo, and Stabersky.
Mhm.
That's a yes?
Oh, I'm sorry, yes. Sorry.
You dated this letter, May 16, 2019.
Right, yes,
You addressed it to Olson, Cannon, Gormley, Angulo, and Stabersky, and CC to Michael Federico.
yes,
You indicated that it's from you,
yes,
Kim Blandino,
yes,
and you titled the subject, Follow-up to Letter of May 9, 2019 requesting settlement with Michael Federico.
yes,
That May 9, 2019 letter was the one that we were just discussing, where you indicated that the drop dead date was May 15, 2019.
No, I don't think I ever said drop dead in there. I said what I said. I mean, I wrote what I wrote, but I don't see, if you want to point to me, I don't think I said drop dead.
Okay. Well, now it's May 16, 2019, and this letter gets sent by you to the board of directors for Mr. Federico's firm, correct?
Did I refer to them as the board of directors? I don't think I did. Let's see.
Okay.
No, I didn't refer to them as the board of directors. No, I didn't write that. I
Okay.
didn't write that.
You sent this letter, you said,
Yes,
and you say right up front, I have asked an attorney for your firm, Michael Federico, to settle issues in regard to his misbehavior in the Las Vegas Municipal Court in his role as alternate judge.
yes,
You indicate that the last letter you sent was May 9th, 2019,
yes,
and you notified him that if you, saying I,
right.
did
Yes.
not hear anything in response, I would notify the firm,
Yes,
and now you're notifying the firm.
Yes, I like to do what I say and say what I do, or right.
Because you're serious.
No, it just, that way people know I'm reliable if I follow through with what I do. I'm missing if I make an appointment and I'm said I'm gonna be there at 8 o'clock, and I'm not there at 8 o'clock, I call them, I let them know I'm late. That's how people know I'm dependable. When people have not heard from me for 15 minutes, they're calling to find out where I am because they know how reliable I am and what I say and what I do. I like to do what I say and say what I do. As much as it's possible.
You like to do what you say and say what you'll do.
Yes.
And so you're serious about what you said.
I don't know if serious is the proper word. I don't know if I could say that. The Bible tells us your reputation precedes you. So people that talk, they say Kim is reliable. I mean, if he says he's gonna be at a place, he's gonna be at a place, or some act of God stopped him from being there. And so,
If Mr. Blandino says he's gonna do something, he's gonna do.
yeah, unless there's some intervening event or something act of God stops me from doing it.
And you said that,
Now, unless I find
You
out
said-
later that it was
hey,
wrong. Okay, I'm sorry.
you said that you were going to send a letter, all this information, to Mr. Federico's firm if you didn't hear from him by May 15, 2019, right?
Yes, I did.
And that's what you did. You
Yes.
didn't hear from him, so you sent all the information to his firm.
Yes, yes.
And then it goes on, because Federico and his various activities can reflect either in a positive or negative on your firm, I believe it is necessary to notify you before I file with the Nevada Commission on Judicial Discipline against Federico.
Yes.
You indicate further that, right here, since I gave Federico till May 23 to settle before filing a complaint, I gave a deadline of May 15 to at least begin good faith negotiations, or I would notify the firm so that the firm has a heads up, in quotes, of Federico, if Federico had failed to inform the firm of this situation when he might be required to do so.
Yes, I wrote that.
You go further, I attached the prior submissions I have sent to Federico for your review.
Yes.
And in fact, you did. You attached everything that you previously provided to Mr. Federico.
Yes.
You attached the letter of April 8th, 2019, or the note.
Mhm.
That's a yes?
Yes, I'm sorry, yes. Sorry.
You attached the letter that you dropped off at his office on May 25th, 2019.
I believe so. Do you have it? Wait a minute, you're saying, repeat that question again.
You attached to this letter, or to
Yeah.
this email.
Yeah, to my recollection, I mean, you have the original there, but to my recollection, I did.
Okay. You attached the document that you entitled Settlement Agreement and Release,
I believe I did, yes.
and you attached your follow-up letter that you sent on May 9th, 2019,
Yes, I believe they should have everything that I was referencing.
as well as all the attachments that you provided with those documents.
Yes. Would you like to know the reason why?
So you go on. That you have both the jabs of the proceedings from April 25th, 2019 and August 2018, correct?
Correct, yes.
Where you indicate here where Federico violated the judicial code as well as other duties, including his oath.
Yes. I'd obtained a copy of his oath of office.
You go further right here. I have spent much time presenting a proposed settlement that is attached to this letter and in addressing the issues directly with Federico.
I'm sorry, where are, I lost you.
Right here, I've spent much time.
Oh, yes, okay, yeah, yes.
You wrote that?
Mhm.
Is that a yes?
Yes, I'm sorry, yes.
You go further, indicating something that you've said before.
Mhm.
My last two complaints to the Nevada Commission on Judicial Discipline resulted in letters of caution to 2 district court judges.
Yes,
So I do not make frivolous complaints.
yes.
then you indicate further that what Federico did is blatantly wrong,
Yes,
specifically referring to events that occurred in court.
yes,
We go to the next page, you write to the firm, know clearly that I'm still very much ready and willing to negotiate with Federico.
yes,
But you indicate, I will need a response within 1 week.
you skipped out a lot of stuff there, so is that deliberate?
Is that what you wrote? That you'll need a response in 1 week?
I wrote some stuff before that though, as a preface to that.
Okay, again, you need to
Okay.
answer the question.
Yes, I
presented.
wrote that.
Then you go on, that if the firm has any say-so in this process of settlement, you see that?
Yes,
You wrote that?
yes,
You indicate that what you would hope is that they encourage Mr. Federico to have a sit-down with you.
yes,
You're hoping that the firm encourages him to further engage with you
yes,
in what you've described as a settlement of your issues with them.
yes,
And then you say here,
well, I write, not say.
okay, you write.
Yeah.
Please look at the attachments and know that this is serious.
Yes. No, could I read the section? You don't want to read that next thing?
Okay, again, remember, he's conducting the examination.
Yeah.
Yeah. You say you really want to deter wrongful behavior in the future by Federico
Yes,
to benefit all.
yes, exactly.
You sign it and you date the letter,
Yes,
include your identifying information or contact information.
yes,
You include in this one as well a certificate of service,
yes,
indicating that you sent this to James Olson,
yes,
Walter Cannon,
yes,
John Gormley,
yes,
Peter Angulo,
yes,
Michael Staberski,
yes,
and Michael Federico.
yes,
And that you did so on May 16, 2019.
yes,
And then we have the attachments. You have the letter that you dated May 8, 2019 that's sent to Mr. Federico on May 9,
yes,
2019.
yes,
The one that we have already gone through.
yes,
You have the exhibits that you attached to that letter.
yes.
You have the document that you entitled Settlement Agreement and Release,
Yes,
the one that we've already gone through.
yes,
You still didn't add anything about your intent to send this to the Nevada Commission on Judicial Discipline.
I'm sorry, what was that question?
You still didn't add anything about your intent to send your settlement agreement, should it be agreed to and signed by Mr. Federico, to the Nevada Commission on Judicial Discipline.
I don't understand the word still, I still didn't, I don't.
Yeah, you still hadn't changed it.
Oh, you still hadn't changed that language there?
Right.
No, not to my recollection.
Yeah.
Not to my recollection, I didn't change.
I'm just going off what you testified to.
Yeah, no, to
Correct.
my recollection, I didn't change anything, I think that's what I said before.
You included as an attachment as well, the letter that you dropped off at Mr. Federico's office on April 25th, 2019.
Yeah,
and that's
at the
what-
reception area, actually, not in his office, but at the reception area.
And that's what we see here.
Yes,
You included the exhibit that you attached to that document,
right,
the customer feedback form.
yes. Mhm.
And it's accompanying several pages and the invoice that you had with that.
Okay, can you scroll that up a little bit? Yeah, that's what's puzzling about this. They have no date on this invoice. There's no date whatsoever, but it looks to be the same as what I sent.
Okay.
What, did I reference that in the letter? Oh, I can't answer the question. I'm sorry. I forgot.
You attached that Veterans in Politics International letter
Yes.
that you attached in the previous
Yes.
submission to Mr. Federico.
Mhm.
And you attach the two letters that you received from the Commission on Judicial Discipline,
Yes.
that you entitled Herndon Complaint and Bear Complaint.
Yes.
And then you attached the note that you wrote at Mr. Federico's office on April 8, 2019.
Yeah, in fact, a copy of the note, but that's not the note, but a copy of it. Yeah.
Okay. You testified a bit on direct about Mr. Federico's fear that he had. You remember that?
On my direct examination, I testified.
Yeah.
You know, what's funny, I may have referenced it, I don't know exactly what context.
I quoted you, I wrote it down here.
Okay.
You said, I don't know how that could be figured.
Okay. The fear is what you're referencing.
Yeah, that's what you're referencing. You
Is
remember that?
Yeah, yes.
You said, I have done this before. No one has ever contacted me. They just ignore me.
That's been my experience, yes.
That you send these kind of letters to other judges in the past,
Yeah, numerous judges,
and they
state
have.
and federal.
Okay. And so, you didn't know how Mr. Federico could be in fear. You couldn't understand that, right?
Yes, based on my experience, yes.
You heard him testify in court about his fear and the steps he took because of it.
Yeah, I heard him, yes, I heard him testify, yes, I heard him perjure himself.
Oh, really?
Yes,
You, in fact, that's extremely offensive. You, in fact, saw him talk about the worry that this caused.
yeah,
for
he
him
was
and his-
committing
Hey!
perjury. Yes.
Mr. Blandino, you've got to let him ask the question.
I'm sorry.
The worry that he
Apologize.
had for his family, specifically his 6 kids. You heard him testify to that?
He perjured himself,
Oh, is that right?
yes.
You saw him tear up here on the stand when he's talking about the fear to his kids, right?
Those were actor's tears. He was acting.
And you sat right there, right?
And I laughed because it was a poor performance for an actor.
You laughed.
I could not help it. When you see a laughable performance by an actor, as an involuntary, my attorney definitely tells me to maintain a post, but that's not me. Everything you see is what I am. And I couldn't help but laugh because it was just a pathetic performance. It was an act. The proof is in the darn videos. When I come into the courtroom on that day, does he call the marshal over here, I'm so afraid or anything? No, he wasn't, because he wasn't afraid. He was arrogant.
You have no empathy.
No, I have empathy when it's deserved.
You have no remorse,
When it's deserved, that's not true. I have remorse.
and you just
No, they're wrong.
are in it for yourself.
No, all for other people.
Is that right?
Yes,
Well, you testified that you did file a complaint against Mr. Federico with the Nevada Commission on Judicial Discipline, right?
yes. Uh-huh.
And you testified that you did that, but you didn't testify when you did that, right?
I thought I was told it was irrelevant. That,
No,
my recollection.
that wasn't brought up. So,
You mean I testified, for clarity, you're saying I testified that I filed a complaint, but I didn't mention when I filed it?
April 8th, 2019, you had not filed a complaint against Mr. Federico.
Oh, no, right, true.
April 25th, 2019, you had not filed a complaint against Mr. Federico.
No, I wanted to settle the thing, that's clear in the
May
letter.
2nd, 2019, you hadn't filed a complaint against Mr. Federico.
No. I
May
mean, that's
3rd,
correct.
2019, you hadn't filed a complaint against Mr. Federico.
Correct, yes.
May 15th, you hadn't filed a complaint against Mr. Federico.
Correct, yes.
May 16th, you hadn't filed a complaint against Mr. Federico.
Correct, yes.
And ultimately, you had some deadlines here. May 23rd, 2019, you hadn't filed a complaint against Mr. Federico.
Wait, what date was that?
May 23rd, 2019.
I was in jail,
Okay.
so it was hard to do anything from there.
In fact, it wasn't until August 28th, 2019 that you filed a complaint against Mr. Federico.
I was kept very busy, that was the earliest I could get to it.
That was months after you were arrested on this case.
Yeah, I had a tremendous amount of legal work to do in regard to this.
And you and your attorney provided me a copy of that complaint, isn't that right?
You asked for it on reciprocal discovery and we supplied it, trying to follow the rules, which I always try to do, is follow the rules.
Because the complaint itself is otherwise confidential.
Well, yes, but can I elaborate on that?
No?
Okay.
So, in the complaint, you indicate that the Nevada Commission on Judicial Discipline should provide Kim the immunity Kim desperately needs.
Yes.
Throughout your document that you sent to the Nevada Commission on Judicial Discipline in August of 2019, you indicate that you are seeking immunity.
Well,
In this case,
I can't answer yes to that because I know I mentioned it once, but I don't know how that I did. You said repeatedly. I have to have that shown to me.
here's
Show
the,
it to me on the screen.
here's the next line. Does this sound familiar? Kim needs immunity so that this evidence, recordings from around the courtroom, can be shown. Does that sound familiar?
It sounds like something I could have wrote, but if I look at it, I could definitely verify.
What about this?
I wrote it.
Kim needs prosecutorial and punishment immunity as to the claim so that Kim can present evidence.
Yes. It sounds like something like that.
So throughout your complaint that you sent months later, you're asking the Commission on Judicial Discipline for immunity.
Because I saw it in the rule of the law and the Constitution that you are entitled to immunity if you're a witness.
Not entitled, right? But that the Commission on Judicial Discipline does in fact have the ability
Oh,
and
okay.
discretion to grant people,
So it's a discretionary thing. Yes, I can agree with that.
that they can grant immunity.
Yes, they have that discretion.
And so, when you reached out to the Commission on Judicial Discipline regarding Mr. Federico, who was seeking immunity for yourself,
As a witness, yes.
from this prosecution, right?
I needed to see exactly how I phrased it in the complaint.
It says right there, I read it to you,
Well, is that
prosecutorial,
published as an
immunity
exhibit?
from prosecutorial
Is that
punishment.
published as an exhibit?
Do you want, a refresher recollection if I
Yeah.
show you right here?
Yeah, I need to look at
Can I approach you on?
it.
Thank
Is
you.
it published as an exhibit though?
Okay, I'm gonna show you here, this line.
Okay.
Kim needs prosecutorial and punishment immunity as to the claim so that Kim can present the evidence. That's what you wrote, right?
Yep, I wrote that. Yes.
You were familiar with the process that was available to you. Isn't that right?
As to what? I don't
As
understand.
to any issues that you took with the August 28, 2018 traffic trial that Mr. Federico sat as the judge on.
Which processes are you talking about?
Well, you were familiar with the process that you could appeal the case,
Yes,
and in fact, you did appeal the case.
yes. There's other things that can be done as well.
And you appealed that to the district court,
Yes,
which is a higher court than the municipal court.
yes.
And you did that on September 14, 2018, you filed that appeal.
Well, if you're saying that that's when the date was, if you want to refresh my recollection, I don't know exactly the date as to that, but it sounds plausible.
Would it refresh your recollection to look at the court docket for that case?
Sure.
May I please approach
You
one?
may.
Thank you. I'm going to show you the docket here, take a look at that.
Okay, well, it's register of actions is what it states. You call it docket, it's register of actions.
Okay.
Yeah.
And this document would have the dates of all the
yeah,
filings.
very familiar with this type of form.
And so the appeal from the lower court occurred on September 14, 2018, is that right?
That was the first filed document with the court, it looks like. Yes, the first
Okay.
filed document. Okay,
There were many things that occurred between that date and the final disposition of the case.
yes, there was back and forth between me as the appellant and the respondent being the city of Las Vegas.
And then ultimately in March 2019, your appeal was dismissed.
Again, if, it sounds like it's a plausible date. If you want to refresh my recollection, I don't know the date off the
You're
top of my
familiar with State's Exhibit 29,
Okay,
right? The order granting respondent's counter motion to dismiss appeal and remand the matter to the lower court.
and then they vacated the March 14th, 2019 hearing, right?
Yes.
Yes.
Respondent would be the city of Las Vegas,
Exactly.
so they court.
Well, they say respondent slash plaintiff, I'm the appellant slash defendant.
Okay,
That's the way they do this.
so their motion to dismiss your appeal was granted. That was filed.
I didn't see that date, you flashed by it too.
Yeah, no problem.
Okay, yeah,
March
that's
7th.
March 7, 2019, at 1:11 PM.
That's all correct, right?
Looks to be, yes.
And then, just about a month later, is when you showed up at Mr. Federico's office and wrote that first note.
I believe my recollection was I asked for an extraordinary writ from the Nevada Supreme Court. Well,
It was denied. You
so I
had,
did do that, that's true.
that, your entire appeal ended with that document. You had nothing left.
No, that's not true.
Okay. The
I
case.
could have gone to the US Supreme Court on the issue. I had that option, and I thought, that's a Hail Mary, a long shot, so I forgo that option. But you can go to the US Supreme Court on that type of issue. Yes.
Okay. And so, that's a Hail Mary.
Yeah. They
So
take it.
instead, you decided to go right to Mr. Federico.
No, not true. That's not
That's
true.
what you did, right?
That's what I did, but that's not why I decided to do that, because of a frustrated appeal, which you seem to be implying.
State pass a witness.
All right, I don't know, Mr. Bateman, anything? Want to allow Mr. Blandino to step down?
indulgence, Your Honor. Mr. Blandino, you I testified earlier that you, during your sort of, what you call it, your activism with the, in sending complaints to the commission, et cetera, that you got a letter of caution issued against Judge Herndon and against Judge Baer.
That's true.
Okay.
Yes.
And you, as proof of that, on the letter to Mr. Federico on April 25th, you attached these as exhibits. And in fact, you attached these letters as exhibits 3L to that letter. Correct? You remember that?
Yes, I believe so. I believe it was 3L.
All right. And I'm showing you here that exhibit 3L from State's Exhibit 4. Now, it's the letter from the commission. Can you recall Mr. Dial being here last week to testify, correct?
Yes, yes.
And recall that he testified about the process, that a complaint goes in, it's reviewed, you recall that,
Yes.
and that either a dismissal is issued, a dismissal with a letter of caution, or then if it's more serious, other steps are taken, you recall that?
Yes.
Okay. Now, you said that in order to know that there's a letter of caution, you have to know how to read the letter.
Yes.
You recall saying that?
And I base that on the fact that I've received so many letters over the years, you could tell from what the language states, what was done, what wasn't done, either expressed or implied.
So, I'm showing here, this is your attachment at the top, that's you testified, I believe, that right here, I'm just pointing. Herndon complaint, you testified that was your annotation?
Right, exactly. So I could identify it because the numbers there, the numerals down there, where it says 20182-216, when you send in a complaint, they send you a letter back, said, we received your complaint, and they show you that they attach that number. So you have to follow along from you. It's best to keep that letter so you can refer back to, because even I don't remember when I file a complaint necessarily. I can look at that number and say, oh, this is the complaint I put in on Judge Herndon, then Judge Herndon.
Okay.
And identify
And
it.
so, explain to the members of the jury, how do you interpret the language of this letter to mean that a letter of caution was issued?
Okay. In that second paragraph, well, can I read that first one and the second? It's not that
Sure.
long.
Can you see it?
The Nevada Judicial Discipline Commission met on March 1, 2019, and decided to dismiss the complaint you filed in the above referenced case based on a review of the relevant court records, including a hearing recording obtained by commission staff. You asserted that the judge called you an inappropriate name, failed to issue an order, made improper legal decisions and various other allegations. Now, in this case, that's another one reason I know that this is the Herndon letter, because this is the only complaint where he called me an a-hole twice in court. This actually videos all over the internet. Millions of people have seen it. Anyway, so that's the only one where I had somebody call me an inappropriate name. So that's another further identification of what this, what judge this indicates. So to go on, although although the commission has dismissed your complaint, comma, it has taken what it considers to be appropriate action under the circumstances. And then, thank you for bringing the facts set forth in your complaint to the commission's attention. This, the only thing they can otherwise do, and Dial testified to that with a dismissal, is either dismiss it without a letter of caution or dismiss it with a letter of caution to the judges. And in fact, this was confirmed in the reports that the commission puts out, and it shows all the different letters of caution, absent the names of the judges. But it'll say, this judge was issued a letter of caution for failure to timeliness. They say district court judge, or justice of the peace, or temporary judge. And they have the grounds on which it was done. So it could be on timeliness, failure to be timely in getting their work done, for administrative neglect, or in this case, for inappropriate demeanor and decorum. The code that governs that is that a judge at all times will maintain a proper decorum and dignity of the court. And I'm sure that that's what they said, hey, don't use that kind of language to a thing and don't be impatient.
Okay, and so, you're saying here it says, by, obviously, that says it's a dismissal, or dismissal of a letter of caution, saying the language here, it has taken what it considers to be appropriate action under the circuit.
Yeah, they have no other
So
option.
you said, what is different, if you get a letter that is just dismissed, is that language, it has taken what it considers to be appropriate action?
Yeah, that's not there on those other letters that I've gotten.
Alright, I'm just showing you other letter that was attached. This one copy's not quite as good,
Okay.
but you do, see the same language there on that first paragraph. Although the commission has dismissed your complaint, it has taken what it considers to be appropriate action. under
Now, this
the
is somewhat
circumstances.
crafted
Is
differently.
that
Yes,
same
that's true,
language
yes.
is there?
Yes.
Okay.
Can I read that next paragraph?
I'm done. If,
All right.
I will back this.
Okay, anything else?
Just briefly. Sir, you attached those two letters to your letter to Mr. Federico, right?
Yes,
Your testimony that you believe that those letters indicate that the Nevada Commission on Judicial Discipline issued letters of caution based upon your complaints.
yes. No,
Okay.
it's an unavoidable conclusion.
You got results.
Yes, I did in those cases, yes.
You're proud of those results.
No, I never, pride is unbiblical,
Okay.
wrong. I was pleased, but not proud.
You're pleased with those results.
Well, I'm not as pleased as I could be, moderately pleased. If they should have really, in my view, published those decisions and given some discipline. So,
Regardless,
yeah.
you attached those for Mr. Federico to see.
Yes, I did.
You attached those so that he knew that you're serious.
No, I see, you use that word serious again. The thing is that I'm not filing, and in the letter I said, I'm not filing frivolous complaints. So, if I had been able to have the letters of caution, but those are not punishment, and they're confidential, then I would have attached those, obviously, to show that,
You get results.
that I have gotten results in the past, yes.
You pass the witness.
Okay. Thank you very much for your testimony here today. You may step down. Mr. Bateman.
No, we have, no witnesses in the defense address.
Can we take a recess, Your Honor?
Sure.
Hey, can we approach?
Sure.
Thanks.
Hey, during this recess, you're admonished not to discuss or communicate with anyone, including your fellow jurors, in any way regarding the case or its merits, either by voice, phone, email, text, internet, or other means of communication or social media. Read, watch, or listen to any news or media accounts or commentary about the case. Do any research such as consulting dictionaries, using the internet, or using reference materials, making the investigation, test a theory of the case, recreate any aspect of the case, or in any other way investigate or learn about the case on your own, or form or express any opinion regarding the case until it's finally submitted to you. This time, we are going to be in recess till about 1:30 in the afternoon. I apologize for that big break. The defense is done calling their witnesses. The state may call more witnesses. If they don't, when you come back, you'll be instructed on the law, and we'll go right into closing arguments. But we are pretty close to being done, and I just apologize for this big break. I also have other hearings that I had to break for at 11 o'clock. So we will be in recess till 1:30. And remember, you'll come up here, Officer Hawks will greet you, and he'll bring you in when we're ready. I do want to extend my gratitude and my thanks to you for being here. I know we have gone a little bit further than anticipated, and I'm very grateful for your willingness to be here. Thank you, and we're in recess.
Thank you. All rise for the next meeting. Very please, sure. Please come to order. Court is now back in session.
Okay, the record will reflect that the hearing is taking place outside the presence of the jury panel. Is the state familiar with the court's proposed 1 through 31 jury instructions?
We are, Your Honor.
Do you have any objection?
We did voice an objection as to the inclusion of an entrapment instruction. It was the state's analysis in this case that the defendant had not met the first prong of entrapment sufficient to have such an instruction, that being that there was inducement or incitement by the government, given his prior actions that really were the inciting offense. So with that, that's the only objection that we're going to voice this time.
Mr. Bateman, do you want to respond to that at all?
Yes, Judge, I would, respectfully disagree with Mr. Dickerson and his analysis. I think we have shown that this was an inducement by law enforcement working through Mr. Federico to suggest illegality, other things that were testified to as to that phone call. It goes to one of our theories of defense, and so I believe it is a proper instruction.
Okay, and I indicated I would give that instruction. Any other objections by the state?
No, I just want to make sure that we didn't include any instruction about the defendant not testifying.
I pulled it out.
Okay.
I pulled it
Yeah, nothing else, Your Honor.
out. Okay, and any additional instructions you'd like to propose?
You don't have anything to stand there. No, Your Honor.
Okay, and you're familiar with the verdict form? Yes.
The verdict form that was submitted and discussed earlier is what we are familiar with, that being,
If you want
Yeah.
to approach, if you want, I have
Okay,
it marked
thank you.
with the clerk.
Mr. Bateman,
yes,
Any objection by the state?
no, Your Honor.
Mr. Bateman?
No.
Okay. All right. And Mr. Bateman, are you familiar with court's proposed 1 through 31?
Yes, Your Honor.
Do you have any objection?
No, Your Honor. What, that one, go ahead, Melanie.
Okay. Do you have any further instructions that you would like to propose?
Yes, Judge, I would ask that we include the instruction on mistake of fact, negating specific intent, since extortion is.
Do you have a copy of the instruction?
Yes. And it appears that I do not have it in my files books.
Okay, so if you wanna proceed and make your record.
Yes, Judge, I would ask that, there was one, there's a sample one from the state. Judge, I believe it does also go to, our theory of defense that, Mr. Blandino was, mistaken as to the fact that he was in a legitimate, negotiation. That this was, in his mind, wrongfully so, the fact that this was not, a negotiation that, that he could engage in. And I think that fact goes to, the specific intent, which would be required to, that would be required to commit an act of extortion, when in his mind, the fact of the matter is that he is engaged in a legitimate legal negotiation.
Any response from the state?
Yeah, Your Honor, there was no mistake of fact instruction that was presented to the court. We did discuss it in argument with that. There was no indication that I saw that in the evidence that there's any specific mistake of fact, and there was none that was argued by defense as to what exists, right? Any mistake of fact that would call for this court to bring in a mistake of fact instruction.
Okay, and I indicated I would not be giving a mistake in fact instruction. Mr. Bateman, any other instructions you would like to propose?
No, Your Honor.
And no objection to the verdict form, correct?
Correct.
Okay, before we bring the jury back in, is the defense going to rest?
Yes, we have.
Let me see.
Okay, I just wanted to make sure.
Yes.
And then, Mr. Dickerson, do you have anything in rebuttal?
With brief indulgence.
Okay.
We had some witnesses lined up in rebuttal. The primary witness that was going to testify is now unavailable due to an emergency at work. Given everything, we're not going to ask to continue. We're going to ask that it just go forward.
Okay, so we'll bring them in and we'll instruct them on the law, and both sides can speak to the jury in their closing arguments.
Everyone, please be seated.
Does the state stipulate to the presence of the jury panel
We do, Your Honor.
and the defense?
Yes, Your Honor.
All right, Mr. Dickerson, does the state have any witnesses in rebuttal?
No, Your Honor. We're ready to proceed to closing.
Okay, thank you. At this time, ladies and gentlemen, you have heard all of the evidence that will be introduced in this trial. It's now my duty as the judge to instruct you in the law. You will all be given a copy of the jury instructions. I am required to read them to you. You can follow along. You will have these instructions to take back with you when you are excused to deliberate upon your verdict. It is now my duty as judge to instruct you in the law that applies to this case. It is your duty as jurors to follow these instructions and to apply the rules of law to the facts as you find them from the evidence. You must not be concerned with the wisdom of any rule of law stated in these instructions, regardless of any opinion you may have as to what the law ought to be, or would be a violation of your oath to base a verdict upon any other view of the law than that given in the instructions of the court. Number two, if in these instructions any rule, direction, ideas repeatedly are stated in different ways, no emphasis thereon is intended by me, and none may be inferred by you. For that reason, you are not to single out any certain sentence or any individual point or instruction, ignore the others. But you are to consider all the instructions as a whole and regard each in the light of all the others. The order in which the instructions are given has no significance as to their relative importance. Number three, an indictment is but a form of method of accusing a person of a crime and is not of itself any evidence of his guilt. In this case, it is charged an amended indictment that on or between April 8th, 2019 and May 21st, 2019, the defendant committed the offenses of extortion and impersonation of an officer. Count 1, extortion, did then and there willfully, unlawfully, feloniously, and with the intent to extort or gain any money or other property and or to influence the action of any public officer, whether or not the purpose is accomplished, threaten directly or indirectly to accuse any person of a crime and or to expose or impute to any person any deformity or disgrace, to wit, by making a demand due Michael Federico, a Las Vegas Municipal Court Judge Pro Tem, for $25 and or enrollment in the Ethics, Fairness, and Security in your courtroom and community class, or in the alternative, pay $500 to the Clark County Library and or provide defendant an apology, including in writing and or in public. And if Michael Federico did not complete this class, pay this money and or provide said apology, defendant would file complaints and or allegations against Michael Federico with the Commission on Judicial Discipline and or would file a criminal complaint with the FBI accusing Michael Federico with a misdemeanor crime under 18 USC 242 and or would send documentation of Michael Federico's alleged misconduct to the law firm of Olson, Cannon, Gormley, Angelo, and Staberski, where Michael Federico was employed. Count 2, impersonation of an officer. Did willfully, unlawfully, and falsely personate a public officer, civil or military, or a police officer or a private individual, having special authority by law to perform an act affecting the rights or interests of another, to wit, an investigator, for the State of Nevada Commission on Judicial Discipline, and in such assumed character did an act purporting to be official whereby another is injured or defrauded by identifying himself verbally and or in writing to one or more persons, including Michael Federico and or P. Marwitz, as an unpaid and or volunteer investigator for the State of Nevada Commission on Judicial Discipline. It is the duty of the jury to apply the rules of law contained in these instructions to the facts of the case and determine whether or not the defendant is guilty of one or more of the offenses charged. Each charge and the evidence pertaining to it should be considered separately. The fact you may find the defendant guilty or not guilty as to one of the offenses charged should not control your verdict as to any other offense charged. Number 4, to constitute the crime charge, there must exist a union or joint operation of an act forbidden by law and intent to do the act. The intent with which an act is done is shown by the facts and circumstances surrounding the case. Do not confuse intent with motive. Motive is what prompts a person to act. Intent refers only to the state of mind with which the act is done. Motive is not an element of the crime charge, and the state is not required to prove a motive on the part of the defendant in order to convict. However, you may consider evidence of motive or lack of motive as a circumstance in the case. Number 5, the defendant is presumed innocent until the contrary is proved. This presumption places upon the state of Nevada the burden of proving beyond a reasonable doubt every element of the crime charge, and that the defendant is the person who committed the offense. A reasonable doubt is one based on reason, is not mere possible doubt, but is such a doubt as will govern or control a person in the more weighty affairs of life. If the minds of the jurors, after the entire comparison and consideration of all the evidence, are in such a condition that they can say they feel an abiding conviction of the truth of the charge, there is not a reasonable doubt. Doubt to be reasonable must be actual, not mere possibility or speculation. If you have a reasonable doubt as to the guilt of the defendant, he is entitled to a verdict of not guilty. Number 6, you are here to determine whether the state of Nevada has met its burden of proof from the evidence in the case. You are not called upon to return a verdict as to any other person. So if the evidence in the case convinces you beyond a reasonable doubt of the guilt of the defendant, you should so find, even though you may believe one or more persons are also guilty. Number 7, the evidence which you are to consider in this case consists of the testimony of the witnesses, the exhibits, and any facts submitted or agreed to by counsel. There are 2 types of evidence, direct and circumstantial. Direct evidence is the testimony of a person who claims to have personal knowledge of the commission of the crime which has been charged, such as an eyewitness. Circumstantial evidence is the proof of the chain of facts and circumstances which tend to show whether the defendant is guilty or not guilty. The law makes no distinction between the way to be given either direct or circumstantial evidence. Therefore, all of the evidence in the case, including the circumstantial evidence, should be considered by you in arriving at your verdict. Statements, arguments, and opinions of counsel are not evidence in the case. However, if the attorney stipulates to the existence of a fact, you must accept the stipulation as evidence and regard that fact as proved. You must not speculate to be true any insinuation suggested by a question asked a witness. A question is not evidence and may be considered only as it supplies meaning to the answer. You must disregard any evidence to which an objection was sustained by the court and any evidence ordered stricken by the court. Anything you may have seen or heard outside the courtroom is not evidence and must also be disregarded. Number 8, the credibility or believability of a witness should be determined by his manner upon the stand, his relationship to the parties, his fears, motives, interests, or feelings, his opportunity to have observed the manner to which he testified, the reasonableness of his statements, and the strength or weakness of his recollections. If you believe a witness has lied about any material fact in the case, you may disregard the entire testimony of that witness or any portion of his testimony which is not proved by other evidence. Number 9, the defendant's testimony in court is to be treated the same as the testimony of any other witness and may be considered for all purposes. Number 10, it is not necessary to call as witnesses all persons who may have been present at any of the events disclosed by the evidence or who may appear to have some knowledge of these events or to produce all objects or documents mentioned or suggested by the evidence. Number 11, a witness who has special knowledge, skill, experience, training, or education in a particular science, profession, or occupation is an expert witness. An expert witness may give his opinion as to any matter in which he is skilled. You should consider such expert opinion and weigh the reasons, if any, given for it. You are not bound, however, by such an opinion. Give it the weight to which you deem it entitled, whether that be great or slight, and you may reject it if in your judgment the reasons given for it are unsound. Number 12, a person who, number 1, with the intent to A, extort or gain any money or other property, or B, influence the action of any public officer, whether or not the purpose is accomplished, threatens directly or indirectly to accuse any person of a crime or to expose or impute to any person any deformity or disgrace is guilty of extortion. Number 13, a specific intent, as the term implies, means more than the general intent to commit the act. To establish specific intent, the state must prove that the defendant knowingly did the act which the law forbids. An act is knowingly done if done voluntarily and intentionally, and not because of mistake or accident or other innocent reason. The intention may be inferred from the defendant's conduct and all other circumstances. You are instructed that extortion is a specific intent crime. Number 14, every person who shall falsely personate a public officer, civil or military, or a police officer or a private individual having special authority by law to perform an act affecting the rights or interests of another and in such assumed character shall do any act purporting to be official whereby another is injured or defrauded shall be guilty of impersonation of an officer. Number 15, officer and public officer includes, number 1, all officers, members, and employees of the state of Nevada, any political subdivision of the state of Nevada, any other special district, public corporation, or quasi-public corporation of the state of Nevada, and any agency, board, or commission established by this state or any of its political subdivisions. All persons exercising or assuming to exercise any of the powers or functions of a public officer. Number 16, Nevada law provides for the appointment of alternate municipal judges, which are known as municipal judges pro tempore or municipal judges pro tem. Municipal judges pro tem possess the same authority as elected municipal judges during their appointment, including jurisdiction over misdemeanor criminal cases in the city of Las Vegas. The city of Las Vegas is a political subdivision of the state of Nevada. Municipal judges pro tem have the power to preserve and enforce order in their immediate presence and in the proceedings before it, as well as to compel obedience to their lawful orders and to the lawful orders of another judge out of court in an action or proceeding pending therein. Number 17, the State of Nevada Commission on Judicial Discipline was established by the Constitution of the State of Nevada. The Constitution of the State of Nevada provides the Commission on Judicial Discipline the authority to censure, retire, remove, and discipline any Nevada judge, including any municipal judge. The Constitution of the State of Nevada further provides the Commission on Judicial Discipline authority to hold hearings, summons witnesses to appear and testify under oath, compel the production of evidence, and grant immunity from prosecution or punishment in order to compel the giving of testimony under oath and the production of evidence. Nevada law provides the Commission on Judicial Discipline authority to employ and or contract with investigators, Nevada law requires the Commission on Judicial Discipline to assign or appoint an investigator to conduct an investigation when it finds a complaint alleges objectively verifiable evidence from which a reasonable inference could be drawn that a judge committed misconduct or is incapacitated. Such an investigation must be conducted in accordance with the Commission on Judicial Discipline procedural rules. Commission on Judicial Discipline investigators have legal authority to compel by subpoena the attendance of witnesses and the production of evidence. At the conclusion of the investigation, the investigator is required to prepare a written report of the investigation for review by the Commission on Judicial Discipline. Number 18, a threat or to threaten another person is a serious expression of the speaker's purpose or intention to harm the person, property, or rights of another by commission of an unlawful act. A threat can include almost any kind of an expression of intent by the speaker to do an act against another person, including through oral and or written words. The speaker need not actually intend to carry out the threat. Number 19, a crime is an act or omission forbidden by law and punishable upon conviction by death, imprisonment, fine, or other penal discipline. Title 18, Section 242 of the United States Code, 18 U.S.C. 242 is a federal criminal statute that provides for a misdemeanor criminal punishment, including imprisonment for not more than a year and a fine. Number 20, extort means influence another person's action through withholding a disclosure of information. Disgrace means to humiliate or cause loss of favor or standing. Number 22, a person can be injured physically, mentally, or financially, which includes suffering damage to their property. Number 23, ignorance of the law is no excuse. Everyone is conclusively presumed to know the law, and one accused of a crime is precluded from using as a defense his ignorance of the law. Thus, when the evidence shows that a person voluntarily did that which the law declares to be a crime, it is no defense that he did not know that his act was unlawful or that he believed it to be lawful. Number 24, a defendant's religious beliefs are neither a defense nor an excuse to the crimes of extortion or impersonation of a public officer. The right to engage in actions or conduct prompted by religious beliefs or principles remains subject to criminal laws enacted by the state of Nevada. Number 25, entrapment is an affirmative defense. The defendant bears a burden of producing evidence of governmental instigation. Once the defendant puts forth evidence of governmental instigation, the state bears a burden of proving beyond a reasonable doubt that the defendant was predisposed to commit the crime. The basic question in determining if the defendant was predisposed to commit the crime is whether the defendant was ready and willing to commit the crime if an opportunity should be presented. 5 factors that are helpful in determining the defendant's predisposition. Number 1, the character of the defendant, who first suggested the criminal activity. Number 3, whether the defendant engaged in the activity for profit. Number 4, whether the defendant demonstrated reluctance. And number 5, the nature of the government's inducement. While these factors are not exhaustive, it is worth noting that the most important factor is whether the defendant demonstrated reluctance, which was overcome by the government's inducement. Raising an entrapment defense places the defendant's character directly in issue. Number 26. Although you are to consider only the evidence case and reach a verdict, must bring to the consideration of the evidence your everyday common sense and judgment as reasonable men and women. Thus, you are not limited solely to what you see and hear as the witnesses testify. You may draw reasonable inferences from the evidence which you feel are justified in the light of common experience, keeping in mind such inferences should not be based on speculation or guess. A verdict may never be influenced by sympathy, prejudice, or public opinion. Your decision should be the product of sincere judgment and sound discretion in accordance with these rules of law. Number 27, while a guilty verdict must be unanimous, you need not be unanimous on the means or the theory of liability in arriving at your verdict. Number 28, in your deliberation, you may not discuss or consider the subject of punishment, as that is a matter which lies solely with the court. Your duty is confined to the determination of whether the state of Nevada has met its burden of proof as to the defendant. Number 29, during your deliberations, you are not to communicate with anyone in any manner regarding the facts and circumstances of this case or its merits, either by phone, email, text, messaging, internet, or other means. You are admonished not to read, watch, or listen to any news or media accounts or commentary about the case. You are not permitted to do any independent research, such as consulting dictionaries, using the internet, or any other reference materials. You're further admonished not to conduct any investigation, test a theory of the case, recreate any aspect of the case, or in any other manner investigate or learn about the case on your own. Number 30, when you retire to consider your verdict, you must first select one of your members to act as foreperson who will preside over your deliberation and will be your spokesperson in court. During your deliberation, you will have all the exhibits admitted into evidence. These written instructions and forms of verdict prepared for your convenience. Your verdict must be unanimous. As soon as you agree upon a verdict, the foreperson shall sign and date the verdict form and return with it to this room. Number 31, now you will listen to the arguments of counsel who will endeavor to aid you to reach a proper verdict by refreshing in your minds the evidence and by showing the application thereof to the law. But whatever counsel may say, you will bear in mind, it is your duty to be governed in your deliberation by the evidence as you understand it and remember it to be, and by the laws given to you in these instructions, with the sole fixed and steadfast purpose of doing equal and exact justice between the defendant and the state of Nevada. And at this time, the state of Nevada may open and close the arguments.
Thank you. Good afternoon, ladies and gentlemen. So, thank you so much for being here for the last 10 days. I know it has been a little longer than everyone expected, but we appreciate you being here and listening to all the evidence. So, as Mr. Dickerson stated when he made his opening statement, this case is about the rule of law. This case is about the judicial process and the authority the courts have over individuals. However, this case is also the rule of law against the rule of Blandino. Mr. Blandino wants to subvert the rule of law to accommodate his own desire for control and power over the courts. I know you guys have listened to this evidence over and over again, so you are familiar with it. You will have that back in the deliberation room with you. But let's go through this timeline once more. So on August 8th of 2018, Mr. Blandino appears in municipal court in front of Judge Pro Tempore Michael Federico for a variety of traffic tickets. At the conclusion of the bench trial, Mr. Federico finds Mr. Blandino guilty of the traffic offenses. Mr. Blandino testified that after that, he did an appeal, as is his right. He appealed the decision to the district court. The district court ultimately found against him and dismissed his appeal. Now, 8 months after that, 8 months after this traffic trial, Mr. Blandino went to Mr. Federico's law office, the law office in which Mr. Federico worked in his capacity as a private citizen, as a private attorney, and attempted to talk to Mr. Federico. Now again, we've had August 28th, we've had the month of September, October, November, December, January 2019, February 2019, March 2019, and now we're on the 8th month after this traffic trial. And this, oh, am I? Oh, it did. It's okay. Thank you. So, 8 months after the conclusion of this traffic trial, wherein Mr. Blandino was found guilty, he shows up at the law office of Mr. Federico, and he tries to talk to Mr. Federico. You heard from Ashley Williams, a receptionist that day, and she indicated that Mr. Blandino was very insistent on trying to find Mr. Federico. She testified that Mr. Blandino asked for a piece of paper in order to write a letter to Mr. Federico. However, she also testified that Mr. Blandino stayed in the reception in the lobby area for about 20 minutes writing this essentially one-page letter. So Mr. Blandino stayed in this lobby area for approximately 20 minutes, writing this short one-page letter while asking Ms. Williams probing questions about Mr. Federico, about whether she knew he was a judge, about whether she'd worked on any cases with him before, basically trying to pull information from Ms. Williams about Mr. Federico. Mr. Federico sat up here on the stand and told you that he was made aware that Mr. Blandino had walked in on April 8th and recognized the voice from this traffic trial 8 months prior. He testified that he went up and had an overview over the lobby area and could hear Mr. Blandino asking questions and basically hanging around until he eventually left. Now, you read that letter. In that letter, Mr. Blandino says, "I am ready to begin filing my complaint against you. Please reach out to me so we can settle matters." So the next day, Mr. Federico, concerned about the fact that a defendant from a traffic trial in which he was found guilty appeared at his law office, Mr. Federico goes and files a report with Metro. 2 weeks after that, Mr. Blandino intrudes upon Mr. Federico's courtroom, where he is sitting as a judge pro tempore once again, and walks in. Now, again, Judge Federico, who has not seen the defendant in 8 months, and who has already filed a complaint and a report against Mr. Blandino, Judge Federico sees Mr. Blandino and asks him to leave the courtroom. Now, yes, was he severe when he told Mr. Blandino to leave? Absolutely. But Mr. Federico sat up there and told you that he was very concerned and that basically he lost the power of speech due to his concern about the fact that twice in the past 3 weeks, Mr. Blandino has basically appeared where Mr. Federico was. Later that day, Mr. Blandino, extremely upset about the court proceeding earlier that day, once again, shows up to Mr. Federico's office in 9950 West Cheyenne, all the way across the city. And he shows up there, and this time he has a pre-prepared letter telling Mr. Federico in no uncertain terms how upset he was about the treatment he received that morning, and told Mr. Federico that once again, he wants to talk to Mr. Federico man-to-man, and he wants to settle matters, or he will be filing a complaint with the Nevada Commission for Judicial Discipline. April 29, 2019, you've heard testimony from Detective Mead, Marshal Marwitz, Mr. Federico, and Mr. Blandino about the fact that there was a call. Now, once Mr. Federico reported once again to law enforcement that Mr. Blandino had showed up in his courtroom and once again to his office on the 25th, Detective Mead, Marshal Marwitz, wanted to do some follow-up investigation. So they go to Mr. Federico's office, talk to Mr. Federico, and they decide to have Mr. Federico call the defendant in order to get additional information. And they want to know what Mr. Blandino means when he uses this term negotiate or settle, because that term was used over and over again in the April 8th and the April 25th letters. So during this phone conversation, Mr. Federico starts off saying, what will it take to get you out of my hair? And Mr. Blandino takes that opportunity to talk to Mr. Federico. Mr. Blandino told you, he has done this multiple times. He has sent letters to multiple judges, and this is the first time someone has called him back. And this was the moment that Mr. Blandino knew that he had some power here. So Mr. Blandino tells Mr. Federico, I want a public apology. Mr. Federico is like, is there anything else that we need to be doing to settle this? Are there any other terms that you want out of this? What do you want in exchange? And Mr. Blandino says, I got to think about it. I know at the very least I want a public apology. So conversation ends there. 3 days later, Mr. Blandino sends a settlement demand to Mr. Federico. And again, you guys have seen that settlement demand. It is basically in exchange for Mr. Federico paying $25 for the JAVS fee in exchange for Mr. Federico making a written apology to Mr. Blandino, in exchange for Mr. Federico paying $500 to the Clark County Law Library, or in the alternative, paying for a $1,500 ethics class up in Reno by a certain date, Mr. Blandino would agree not to file a complaint with the Nevada Commission for Judicial Discipline for the incident that took place on April 25th of 2019. Mr. Blandino further asks and further demands in this settlement agreement that Mr. Federico, when he sits as a judge pro tempore, allow him free access to the courtroom at any time. When Mr. Blandino doesn't hear back from Mr. Federico, Mr. Blandino gets upset. Now, in this May 8th, 2019 letter, we have a couple, if you don't do this, then I will do this. We have the, if you don't get back to me about the settlement demand I made, I will file a complaint with the FBI under 18 U.S.C. 242, which is a criminal misdemeanor in federal court. So if you don't do this, I will do this. Moreover, Mr. Blandino states that, by the way, if you don't get back to me within another week, I think that your bosses need to know exactly what you did, and I think your bosses need to know that they're exposing themselves to disrepute by keeping you employed, essentially. So, two threats there. One, to file a complaint, a criminal complaint with the FBI, and two, well, let me tell your bosses how bad of a person and how bad of a judge you are. And finally, a week after that, Mr. Blandino follows through with that threat from May 8th and actually sends a letter to the law firm of Wilson, Cannon, Gormley, Angulo, and Seversky, who employ Mr. Federico. So there's our timeline. In every criminal case, the state has two things to prove. One, that a crime occurred, and two, that the defendant committed the crime. Now, okay, ladies and gentlemen, this is not a whodunit, right? We all know who was involved in this case. Mr. Blandino himself admitted that he wrote every single one of those letters. He admitted he wrote every single one of those letters, made the statements in those letters, and he testified on the stand as to the actions that took place on August 28th, 2018, on April 8th, 2019, April 25th, 2019, May 2nd, May 3rd, May 8th, and May 16th of 2019. So this isn't a whodunit. Mr. Blandino committed the crimes that are charged. Now, the second thing that the state has to prove to you beyond a reasonable doubt, and you have your beyond a reasonable doubt instruction, is that the defendant committed the crimes charged. So Mr. Blandino committed the crimes of extortion and impersonation of a public officer. We're going to break down those elements a little bit because the instructions that were provided to you as to what those crimes are a little lengthy. So what is extortion? Essentially, if you do X, then I won't do Y, or I will do Y unless you do X. Again, that May 8th letter, ladies and gentlemen, has that specific language. I will send a copy of all the relevant documents to OCGA&S unless I hear from you by May 15th of 2019. Ladies and gentlemen, that is textbook extortion. Here are the elements. So this is your instruction, and essentially a person who, with the intent to extort, gain any money or other property, or influence the actions of any public officers, whether or not the purpose is accomplished, threatens directly or indirectly to accuse any person of a crime or to expose or impute on any person any deformity or disgrace, is guilty of extortion. The elements I want you to focus on are the threat, whether direct or indirect, and the intent behind Mr. Blandino's statements to Mr. Federico. Again, it doesn't matter whether the intent is, it doesn't matter whether Mr. Blandino was actually paid that $25. It doesn't matter whether Mr. Blandino actually actually gets this apology from Mr. Federico. It doesn't matter if Mr. Federico doesn't pay the $500 to the Clark County Law Library. What matters is that these are the statements that were made. So what constitutes a threat? You have an instruction about that. You're going to have an instruction about pretty much everything. A threat is a serious expression of the speaker's purpose or intention to harm the person, property, or rights of another by commission of an unlawful act. A threat can include almost any kind of an expression of intent by the speaker to do an act against another person, including through oral and/or written words. The speaker need not actually intend to carry out the threat, right? So a threat, you just need to intend to speak those words to another person for a specific purpose. In this case, the specific purpose that Mr. Blandino had, his intent for all of the crimes that we've charged, is he wants power and he wants control, right? He lost his traffic trial, he lost his appeal. The judges against whom he's filed complaints, the judges to whom he sends letters, basically ignore him. He testified to that. But Mr. Federico did not ignore him. Mr. Federico gave him that idea that, hey, I can get some power here. I can have a little control here. So Mr. Blandino can file as many complaints as he likes. Mr. Blandino can file as many reports to the FBI as he wants. That is not an unlawful act. He can do that. Paul Diley from the Nevada Commission of Judicial Discipline told you he is free to file complaints. That is not what the unlawful act is. However, making that complaint or report contingent on someone doing or not doing something, that is an unlawful act. If I know that someone committed a crime and I say, hey, you know, I know you did this, but if you pay me, you know, whether it's $10, $100, $1 million, it doesn't matter. But I know you did this, so unless you pay me X, I'm going to report you. That, ladies and gentlemen, that's extortion. And it doesn't matter. Again, I understand that $25 is not $1 million, it's not $10,000, but $25 in the manner in which it was demanded from Mr. Federico, that is an unlawful act. Okay, extortion. What kind of threats are we talking about? We are talking about a threat to accuse a person of a crime or to expose or impute any disgrace upon another person. In this case, we have both. I talked about that May 8th, 2019 letter that Mr. Blandino sent to Mr. Federico. Now, that letter contains both of those. And I would note that you don't need to agree, all 12 of you don't need to agree that he threatened to accuse a person of a crime. 5 of you could say, hey, he threatened to accuse Federico of a crime, and the other 7 could agree that, he threatened to impute a disgrace on Mr. Federico. As long as all 12 of you agree that there was a threat, directly or indirectly, to do one of those 2 elements, we have Mr. Blandino guilty of extortion. So, May 8, 2019, I discussed this. Mr. Blandino tells Mr. Federico, by kicking me out of the courtroom, you violated important civil rights. In fact, you can be criminally prosecuted for a misdemeanor violation of federal civil rights under 18 U.S.C. 242 for your action on April 25th of 2019. Ladies and gentlemen, that is threatening Mr. Federico and telling him that he is going to accuse Mr. Federico of a crime. Again, that next page. If we cannot come to a settlement, I believe it would be proper to go to the FBI with a criminal complaint against you for stopping me from observing you on the bench on April 25th, 2019. Granted, this would only be a misdemeanor. However, it may help others that come after me should you not agree to the apology and settlement. So there's your threat to accuse someone of a crime, again. And same letter, May 8, 2019. Further, Mr. Blandino then, in that same letter, threatened to accuse Mr. Federico, basically threatened to impute disgrace, right? So he told Mr. Federico, like, I am going to tell your bosses that you committed ethical violations unless you actually have to sit down with me and discuss what I want. So, I've come to realize that since you work within a partnership titled Olson, Cannon, Gormley, Angulo, and Seversky, OCGA&S, that I should give some notice to these individuals of the matters involved prior to filing with the NCJD or the FBI. The calculus for this is simple. Putting myself in the place of any one of these partners and everything else being equal, I would want to know that a person who worked with the firm and had a prominent webpage was not bringing any disrepute in any way to the firm or its name. Ladies and gentlemen, this could not be more clear. Mr. Blandino told Mr. Federico that, you know, I think that your bosses would like to know exactly what you did. And I think they would be very concerned to know that, you know, you could bring them disrepute. Essentially, Mr. Blandino, what he is doing here is not only imputing disgrace on Mr. Federico, but he is also threatening his livelihood, right? Because you're telling Mr. Federico's boss that Mr. Federico is a bad person, that he may have complaints filed against him, that he may bring bad publicity, essentially. With those words, Mr. Blandino is telling Mr. Federico, you better listen to me. You better take me seriously or I will do this. Unless you sit down with me, I am going to tell your bosses about this. So again, Mr. Blandino keeps going about how he's doing this for the greater good. He's really just, you know, he wants Mr. Federico's bosses to be aware of this because that's what his religious beliefs prompt him to do. That last line, therefore, consistent with my beliefs, I will send a copy of all the relevant documents to Olson, Cannon, Gormley, Angulo, and Seversky unless you get back to me by May 15th of 2019. Now, we've gone through those threats that constitute the elements of extortion. We have Mr. Blandino threatening Mr. Federico with federal crime, and we have Mr. Blandino threatening Mr. Federico with going to his bosses and assigning disgrace upon Mr. Federico's name to his bosses. Then we go into the intent. What was the intent behind those threats? For extortion to be met, you need to have Mr. Blandino's intent to be either to extort or gain money or other property, or influence the action of another officer. Now let's look at the specific language in these letters that Mr. Blandino has sent to Mr. Federico and the statements Mr. Blandino made on the stand. Let's look at his testimony. Mr. Blandino sat up there, we watched this Javs video of that traffic trial for a second time, and Mr. Blandino listed out every instance where he saw conduct that could, in and of itself, be the basis of a complaint to the Nevada Commission for Judicial Discipline. I believe Mr. Blandino, at the end of his testimony, told you, I counted at least 5 actionable offenses during that traffic trial. However, that traffic trial was August 28th of 2018. He did not report any of this behavior, any of these actionable behaviors for 8 months. Mr. Blandino instead did as is his right and appealed his conviction. He lost that appeal, and only then did Mr. Blandino decide, hey, you know, I'm going to take matters into my own hands here, and I'm going to make sure that I get a little power, I get a little control, and I get to tell Mr. Federico, Judge Federico, what's what. And Mr. Blandino told you that, hey, if at any time Mr. Federico had said, buzz off, make your complaint, I'd have stopped and filed my complaint. Ladies and gentlemen, I would submit to you that Mr. Federico ordering Mr. Blandino out of the courtroom on April 25th of 2019 was precisely that. That was Mr. Federico telling Mr. Blandino, you are not to come to my office, you are not to bother me, essentially. You are not to bother me in my capacity as a private citizen. But what did Mr. Blandino do later that very same day? He went back to Mr. Federico's office, ladies and gentlemen. He went back because at that point he knew that he got under Mr. Federico's skin. He knew that he had gotten under a judge's skin, and he knew that he had to keep going. He wants that control and he wants that power. Now, let's talk about, what the intent was, what those terms were that the defendant wanted from Mr. Federico. He wanted money or property. Again, it could be $1 million, it could be the $25 for the joust. He wanted money in exchange for not filing that criminal complaint. But let's look at his statements. April 8, 2019. Essentially, if you don't agree to settle, I will file a complaint. I am ready to begin filing my complaint against you. I am required by my religious beliefs and practices to give you an opportunity to negotiate a settlement. Please let me know within the next 10 days. My last 2 complaints resulted in letters of caution to the judges. Please don't take this matter lightly. Now, ladies and gentlemen, first of all, speaking about those letters of caution, Mr. Darley testified that letters of caution are confidential, and nothing in any of those letters that were presented to you says the word it's a letter of caution. I know Mr. Blandino believes there is, or testified that there was some secret code within the language of each of these letters that made him believe that they were letters of caution, but you don't have any evidence that these were letters of caution. But I would note that Mr. Blandino does believe that those were letters of caution. He
Mr.
attached them.
Blandino, please. Sorry, go ahead.
Sorry.
Mr. Blandino attached those letters that he believed were proof that he could get a judge in trouble, essentially, to the letter he sent to Mr. Federico. And he attached those on April 8th, 2019, the very first time he made contact with Mr. Federico. Actually, I apologize. He attached those letters on the April 25th letter. He mentions them only in the April 8th letter. Essentially, the meaning behind the April 8th handwritten letter is, hey, if you don't want to be in the same position of those judges and receive a letter of caution, you need to get back to me. April 25th, 2019. This letter could essentially be titled, "Talk to me and settle the matter, or I will file a complaint." So unless you talk to me, I will do this. Unless X, then Y. The subject line, desire not to have to file a formal complaint with the NCJD. I mean, in exchange for what? So, Mr. Blandino, putting himself out there as an investigator for the NCJD, tells Mr. Federico that he came to your office to see if I could meet you man to man and see if we could resolve my complaint with you without having to use scarce judicial resources and NCJD resources, as I have attempted to do with other misbehaving judges. Now, we're going to talk about the impersonation charge in a minute, but let's just go to that. I am an investigator with the Nevada Commission for Judicial Discipline. Mr. Blandino is not an investigator for the Nevada Commission for Judicial Discipline, never has been. But by announcing himself as such, he cloaks himself in that authority. When he's writing this letter, he is putting on the cloak of authority that the NCJD has over judges, including municipal court judges who are public officers and who are subject to judicial discipline. And Mr. Blandino puts that at the very top of that letter, and then goes on to say, I need you to start talking to me, or I'm going to file a complaint with the Nevada Commission for Judicial Discipline. To avoid having the NCJD subject this complaint to their protocols, I once again reach out to you to resolve this matter between you and I, or your attorney and I, if you wish to have an intermediary. I will do X unless you do Y. May 3rd, 2019, this settlement demand is essentially a quid pro quo, which is this for that, in consideration, meaning in exchange for. So in exchange for Judge Pro Tempore Federico paying a $25 fund to defendant for that jabs, in exchange for Judge Pro Tempore Federico writing a written apology to Mr. Blandino, in exchange for Mr. Federico acknowledging that the defendant can observe court whenever he wishes, and in exchange for Mr. Federico completing that ethics course or paying that $500 to the Clark County Law Library. In exchange for that, the defendant agrees that he will not file a complaint with the NCJD, and he will withdraw and dismiss the municipal court complaint form that he had previously filed with the municipal court. If not X, then I will do Y. So this is, on one hand, Mr. Federico is to do the things that Mr. Blandino is demanding in the settlement agreement, and on the other hand, Mr. Blandino agrees that he will not be filing that complaint. He will not be imputing disrepute upon Mr. Federico. He would not be filing any complaint that could bring that disrepute upon an individual who acts as a judge. Mr. Blandino goes on in this agreement to state essentially that, this agreement bars Mr. Blandino from filing that complaint with the NCJD and the court or agency or any reviewing entity whatsoever with respect to the April 25th issues. Words matter to Mr. Blandino. I'm sure you guys noticed that when Mr. Blandino was on the stand, he was very particular about the words that were used, about the questions that were asked. Mr. Blandino had a hard time answering questions with a yes or no when that was what was requested. Mr. Blandino is peculiar with his words and particular with his words. And I would note that on the stand, Mr. Blandino said, oh, but I should have put in there that I would have sent that settlement agreement to the NCJD anyway. Because, hey, if Mr. Blandino is that particular with his words, that would have been in that settlement agreement. May 8th, 2019, again, Mr. Blandino at this point is extremely frustrated. There has been that call between Mr. Federico and Mr. Blandino. And Mr. Blandino wants a response to that settlement demand. He wants a response because he spent a lot of time working on the settlement demand, a lot of time working on his letters, and he wants to make sure that that little bit of power that he had over Mr. Federico keeps going. So I will need an answer or for you to otherwise respond to this proposed settlement on or before May 23rd, 2019. I sincerely hope we can settle things. And when we talk about the settling things, again, I would note that this refers back to that settlement demand, the settlement agreement that Mr. Blandino drafted. In this case, and this is the letter in which Mr. Blandino threatens to accuse Mr. Federico of a federal complaint, and in the letter in which Mr. Blandino threatens to go to Mr. Federico's bosses and accuse Mr. Federico of judicial misconduct. So if we cannot come to a settlement, I believe it would be proper to go to the FBI with a criminal complaint against you. Again, if you do not do X, then I will do Y. Textbook extortion, ladies and gentlemen. Again, the threat of reporting this to Mr. Federico's bosses, I will do this if you do not do Y. Textbook extortion again. So again, it doesn't matter that whether or not Mr. Federico pays that money, doesn't matter whether Mr. Federico ever actually sat down with Mr. Blandino, doesn't matter if there was an apology, the $500 to the Clark County Law Library. This is extortion. So there is a threat that was made to accuse Mr. Federico of a crime under 18 U.S.C. 242, and there was a threat to impute on Federico disgrace, which I'm going to go to your bosses and tell them that you're a bad judge. So we have Mr. Blandino threatening to accuse Mr. Federico of a crime and threatening to impute on Federico any disgrace. So that threat element for the extortion charge is met, ladies and gentlemen. Now, the intent. Extort or gain property or money. Mr. Blandino asked for that $25, asked for that $500 to the Clark County Law Library. That is trying to gain money or property from Mr. Federico. And again, I would tell you, this is an either or. Not all of you have to agree on what Mr. Blandino's intent was according to this element. Some of you may believe that his intent was to extort or gain property or money. Others may agree that Mr. Blandino's intent here was to influence the action of a public officer, because you have that instruction. Mr. Federico, when he is sitting as a judge pro tempore in municipal court or as an alternate judge in municipal court, is a public officer. So what type of influence is Mr. Blandino trying to get? He is trying to get a either public or written apology from Mr. Federico in exchange for not accusing him of a crime, in exchange for not filing a judicial complaint, in exchange for not reporting Mr. Federico to his bosses. He is attempting to get an apology, and he is attempting to have Mr. Federico agree that Mr. Blandino has free reign over the courtroom. There's your intent element. And again, whether or not the purpose that is intended is accomplished doesn't matter. The intent was there when the threat was made. Mr. Blandino is guilty of extortion. Count 2, impersonation of a public officer. Every person who shall falsely personate a public officer, civil or military, or a police officer, or a private individual having special authority by law to perform an act affecting the rights or interests of another, and in such assumed character shall do any act purporting to be official, whereby another is injured or defrauded, shall be guilty of impersonation of an officer. So, a few elements here. We have falsely personating. So basically, Mr. Blandino needs to pretend to be a public officer. The public officer we have here is an investigator with the Nevada Commission for Judicial Discipline. In such assumed character shall do any act purporting to be official, here communicating with a judge pro tempore, talking about negotiating with a judge pro tempore while claiming to be an investigator, and whereby another is injured. Mr. Federico told you that he was injured. He suffered mental anguish, and he was stressed, and he thought he was going to lose his job. He was scared for his children. He testified that he began carrying a firearm because he was so frightened for his wife and 6 children. Mr. Federico sat up there and teared up. Mr. Federico was extremely scared of Mr. Blandino at the time. So, here are your elements. Someone needs to pretend to be a public officer, do an action purported to be official that causes injury to another. Again, defendant does not work for the Nevada Commission for Judicial Discipline. He's never worked for the Nevada Commission for Judicial Discipline. However, Mr. Blandino is incapable of admitting that he does not work for the Nevada Commission for Judicial Discipline. Paul Diley sat up there and told you, it doesn't matter whether you tout yourself as a volunteer or official or unofficial. Mr. Blandino is not an investigator, nor has he ever been. So, the Nevada Commission for Judicial Discipline, you'll have an instruction detailing what that is. It's established by law, by the Nevada revised statutes, by the Nevada Constitution. The procedure is essentially, there's a complaint that's confidential. The commission staff, including Paul Diley, review that complaint, that initial complaint that can be made by absolutely anyone, including Mr. Blandino, and determine whether it meets a certain threshold of proof. If they find that it does meet that threshold of proof, the next step is they authorize an investigation. Mr. Diley told you that when it comes to their investigators, there is a very set category of people who meet that standard. Mr. Diley told you that they use the same firm, and when they engage these investigators to work for the commission, those investigators become public officers. Once the investigation is done, and at this point it is still confidential, once the investigation is done, the investigators submit reports to the commission reviews the evidence, and determines whether or not they need to get a response from the judge. The judge response is reviewed by the Nevada Commission for Judicial Discipline, who again at that point determine whether or not charges need to be brought against the judge. Investigators have special authority under Nevada law. Specifically, they can compel judges, lawyers, and court staff. They can compel the production of court documents. They can compel cooperation by judges, officers of the court, who have to comply and provide documents. Those investigators that Paul Diley mentioned are separately licensed under Nevada law, and they become public officials when the NCJD brings them into an investigation. Mr. Blandino's only role when it has come to any type of investigation by the NCJD has been to file that initial complaint. Mr. Blandino does not investigate for the Nevada Commission for Judicial Discipline. Mr. Blandino investigates for himself. Let's be clear. He investigates for himself because he wants to get that power and control over the judiciary. Mr. Diley, Kim Blandino is not or ever has been an investigator for the NCJD. He's not an investigator for his commission. This is everything Mr. Diley testified to. It causes me concern when someone who is not authorized by the commission is holding himself out as an investigator. Mr. Diley testified that no charges were brought against Mr. Federico, nor was any discipline ordered. And there was this interesting exchange because Mr. Blandino's new tactic, at least on the stand, was to claim that he actually says that he's an unofficial investigator. Therefore, that means that he can do it. But Mr. Diley disagreed. Defense counsel, Mr. Blandino indicated that he was unpaid volunteer investigator for the commission. When to infer that unpaid and volunteer isn't anything official. Paul Diley testified that I would not agree with that. So it doesn't matter whether or not Mr. Blandino is paid or unpaid. It doesn't matter whether or not Mr. Blandino is a volunteer or employed officially by the Nevada Commission for Judicial Discipline. Mr. Blandino cannot say that he is an investigator with any adjective in front of it for the Nevada Commission for Judicial Discipline. And Mr. Blandino, again, is incapable of admitting that he is not an investigator. You saw him. The first questions on cross-examination were, you are not an investigator for the Commission for Judicial Discipline. I'm an unofficial investigator. So, again, the defendant has claimed to be an investigator for the Nevada Commission for Judicial Discipline over and over again. In all these letters to Mr. Federico, starting on April 25th, 2019, I am an investigative reporter and an unpaid volunteer investigator for the Nevada Commission for Judicial Discipline to investigate judicial misconduct and corruption. I was there today in these joint capacities. So not only is Mr. Blandino telling Mr. Federico in this April 25th letter that he is an investigator with the Nevada Commission for Judicial Discipline, but he is saying that he showed up in court that morning under that cloak of authority. He showed up in court as an investigator for the Nevada Commission for Judicial Discipline. That is what that statement means. Again, May 2nd, 2019 settlement demand. Complainant, Kim Blandino, pro se litigant, an investigative journalist and volunteer unpaid investigator for the Commission on Judicial Discipline. Mr. Blandino is putting himself out there as a public official for the Nevada Commission for Judicial Discipline. There are no investigators pre-complaint to the Nevada Commission for Judicial Discipline. That does not exist under the NCJD rules. May 8th, you can ask just about anyone in the RJC and they will tell you that Kim Blandino is investigating judicial misconduct and corruption and has done so for many years. Again, Mr. Blandino goes on and tells any threat to tell Mr. Federico's bosses that Mr. Federico was mean to him that morning and was a bad judge to that morning. Mr. Blandino says, I would not want anyone associated with a firm that had my good name on it, associated with a member of the bar that excluded a member of the public from an open courtroom, let alone an investigator and journalist from a public courtroom. Now, again, Mr. Blandino is threatening Mr. Federico here with disgrace from his bosses, but also saying that it's even more egregious that you would do it when I was an investigator for the Nevada Commission for Judicial Discipline. Defendant, again, this was the exchange I mentioned where Mr. Blandino is incapable of admitting that he does not work for the Nevada Commission for Judicial Discipline. So Mr. Blandino, you're not an investigator for the Nevada Commission for Judicial Discipline. Well, I'm an unofficial investigator. Mr. Dickerson. So are you telling this jury that you are an investigator for the Nevada Commission for Judicial Discipline? Mr. Blandino, unofficially, yes. Mr. Dickerson, no, you're not, sir. And Mr. Blandino, well, that's not true. When confronted by Mr. Dickerson, you heard the testimony of Paul Daly, same as I did, right? That you are not and never have been an investigator for the Nevada Commission for Judicial Discipline. And Mr. Blandino sat right here and told you, I disagree. I'm an unofficial one. So, ladies and gentlemen, Mr. Blandino is still putting himself out there as an investigator for the Nevada Commission for Judicial Discipline. He's met the elements in terms of putting himself out there as a public official, pretending to be a public official, doing an action purporting to be official, that being to investigate judicial misconduct for the Nevada Commission for Judicial Discipline, which he was not authorized to do by the Nevada Commission for Judicial Discipline. And then you have the injury to Mr. Federico, which I mentioned. The worry about losing his job, the worry about getting in trouble with the partners, the worry about losing his additional employment as a judge pro tempore should the complaint be filed with the commission, as well as his physical fear of Mr. Blandino. So impersonation. Those are the elements, and ladies and gentlemen, they are all met. Mr. Blandino pretends to be an investigator for the Commission for Judicial Discipline, who is a public officer. He does actions purported to be official, so he tells judges that he is investigating misconduct and they need to sit down with him, basically, or else. And it caused an injury to another, in this case to Mr. Federico. So let's talk a little bit about the potential defenses we have here. Mr. Blandino may allege a defense of mistake of law. He might say, look, I didn't know that what I was doing was wrong. He might, and Mr. Blandino has said that his religious beliefs require the actions he took. Mr. Blandino has said over and over again, his religious beliefs require that he settle matters. His religious beliefs prompt him to speak in the manner in which he does. Finally, the defense of entrapment. Now let's go through those one by one. Mistake of law. You have an instruction on that because you have an instruction on everything. So ignorance of the law is no excuse. Everyone is conclusively presumed to know the law, and one accused of a crime is precluded from using as a defense his ignorance of the law. Thus, when the evidence shows that a person voluntarily did that which the law declares to be a crime, it is no defense that he did not know that his act was unlawful or that he believed it to be lawful. So, Mr. Blandino testified on direct. If there was any extortion, that was a mistake on my part. Ladies and gentlemen, that's not a defense. The question you need to go back and deliberate on is, have the elements of the crimes been met? And I would submit to you that they have. So mistake of law is out. Ignorance of the law is no excuse. Next, potential defense, religious beliefs. Defendant again stating that his religious beliefs required everything that was done. A defendant's religious beliefs are neither a defense nor an excuse to the crimes of extortion or impersonation of a public officer. The right to engage in actions or conduct prompted by religious beliefs or principles remains subject to criminal laws enacted by the state of Nevada. And if you think about it, that makes sense because we're a government of laws. We're not a government of individuals. The laws dictate what everyone must do. The laws need to be generally applicable. If a person's personal religious beliefs could exempt them from certain laws, what use is the rule of law? What use is having a generally applicable law? You got your typical example of taxes. Some people think they don't need to pay taxes for religious reasons. Some people believe that, they can have 5 husbands or wives for religious reasons. Age of consent. So there are so many examples of laws that the state has that apply to everyone that individuals may believe their religious beliefs exempt them from. There is a reason the religious beliefs do not excuse or defend against criminal action. So Mr. Blandino's religious beliefs while they are sincere, are not an excuse to the crimes of extortion and impersonation of a public officer. The question you must ask yourself is not, did Mr. Blandino believe that God was telling him to do this, but rather, did Mr. Blandino commit the elements of each of these crimes? And the answer to that is yes, he committed those crimes. So religious beliefs, not an applicable defense. Finally, the defense of entrapment. So the defense of entrapment is an affirmative defense the defense must raise, and they have. That being that they need to argue that there was some instigation by law enforcement. So that phone call of April 29th is what we're really talking about here. That is the law enforcement action that defense claims constituted entrapment. But once that defense is raised, the state must prove that the defendant was predisposed to commit the crime. Ladies and gentlemen, Mr. Blandino was predisposed to commit this crime. Mr. Blandino testified that he had sent letters such as the ones he sent Mr. Federico to dozens of judges. He testified that this was just the first time someone had ever responded, but he had done it a lot. So predisposition, again, an instruction of things you may consider to determine whether or not Mr. Blandino is predisposed to committing extortion and impersonation of a public officer. So you may consider his character, you may consider where that first suggestion of criminal activity comes from, whether Mr. Blandino was engaged in criminal activity whether he was engaged in activity for profit, whether he was reluctant to take advantage of the opportunity presented by law enforcement, and the nature of the inducement. So, going through those very quickly. The defendant's character, again, you saw Mr. Blandino's demeanor throughout these proceedings. You saw his demeanor while Mr. Federico was testifying. You saw his demeanor on the stand. You saw Mr. Blandino's inability to answer questions directly. And you saw Mr. Blandino's desire to control the testimony. Furthermore, I would submit that first suggestion of criminal activity, that first suggestion of extortion, came from Mr. Blandino in that very first letter on April 8th, 2019, wherein Mr. Blandino stated, "I am ready to begin filing my complaint against you. I need you to meet with me to negotiate a settlement." Ladies and gentlemen, that letter, the letter on April 25th, 2019, where Mr. Blandino followed through saying, "I want to meet man to man, I want us to settle matters, I need us to negotiate." Those are the first suggestions of criminal activity. Those are the first suggestions of extortion that came from Mr. Blandino. Engaged in activity for profit. We're not alleging that Mr. Blandino is in this to get rich. We're not. Mr. Blandino wants power. Mr. Blandino wants control. Mr. Blandino wants $25 for the repayment of the jabs. So specifically though, I would note that there was no reluctance whatsoever on Mr. Blandino's part when it came to whether or not to take advantage of that phone call and Mr. Federico's willingness to talk to Mr. Blandino. Mr. Blandino was giddy. Mr. Blandino was happy. He was excited. Mr. Blandino went on and on for approximately 18 minutes where he controlled that conversation. And Mr. Blandino demanded a public apology during that phone call. When that conversation ended, within 3 days, Mr. Blandino had drafted a multiple-page settlement demand. So, ladies and gentlemen, I would submit to you that entrapment in this case is not a defense. Mr. Blandino has sent letters to judges before, has filed complaints against judges before, has sent similar letters as he did to Mr. Federico to other judges before. And Mr. Blandino took advantage of the opportunity that was provided to him when, for the first time, someone actually decided to give him a little bit of power. There's your testimony that I was speaking of. Truthfully, he, meaning Mr. Federico, is the only one who ever came back. And everyone else, they just pretty much ignore me, and I just filed my complaint, and in a few cases, they issue a few letters of caution to the judges. Mr. Blandino admits to sending similar letters. This is not entrapment. The defendant here was predisposed to committing extortion. How else do you know that? Look at the photographs from that search warrant. There's Mr. Blandino's room, his mission control center, with all those computers. And then there's his filing system. There's all that paperwork that Mr. Blandino has in his bedroom. There's a file entitled Judge Screw-Ups. And there's a file entitled Federico Case. Ladies and gentlemen, Judge Screw-Ups, all those documents in that filing cabinet, I would submit to you that the defendant has done this before. He admitted he's done this before. That is predisposition. That is predisposition to commit extortion. So entrapment is out. Now, let's talk a little bit about Don Quixote. In opening, Mr. Bateman told you that Mr. Blandino is like Don Quixote, right? He wants nothing for himself. However, what he does want is, $25, an apology, free access to a courtroom, and for a public officer to do an ethics course or pay an additional fine. Mr. Blandino wants nothing for himself except for Judge Federico to settle matters expeditiously. Or else, Mr. Blandino is going to file a complaint with the FBI for a federal crime. Or else, Mr. Blandino is going to complain to Mr. Federico's bosses about Mr. Federico's alleged misconduct. So, Mr. Blandino wants nothing for himself except the ability to exercise some control over one judge who got back to him and gave him the feeling that he could get that control. Mr. Bateman told you, defendant was within his rights to observe court and submit complaints to the Nevada Commission for Judicial Discipline. And absolutely, Mr. Blandino can file as many complaints to the Nevada Commission for Judicial Discipline as he wants. What he is, however, not entitled to do is decide to settle matters for himself. Mr. Blandino cannot play the investigator. Mr. Blandino can file a complaint. If I'm driving down the freeway and I see one car ram another, I can call 911. I can't track one of the cars back to the house and then start trying to talk to the perpetrator, cloaking myself in this cloak of authority, like, hey, I'm a volunteer police officer here, so tell me what happened. I can't do that. Ladies and gentlemen, he can observe court, he can file complaints, he cannot investigate, and he certainly cannot investigate when he's saying he's investigating for the Commission for Judicial Discipline. Mr. Blandino also told you, I got a deliberate plan to help the NCJD with their plan. Mr. Blandino wants to help the Nevada Commission for Judicial Discipline. That's great. However, Mr. Blandino says he's doing all this for other people. In his letters, the defendant is saying, I am doing this for everyone else who may appear in front of you because I don't think you have the temperament for a judge, essentially. If that were the case, ask yourself this. What was that gap in that timeline? Why not file that complaint to the Nevada Commission for Judicial Discipline as soon as that August 28, 2018 trial resulted in Mr. Blandino's conviction? Why wait 8 months? Mr. Blandino, I submit to you, waited 8 months because he wanted to try to win on appeal, but he lost on appeal. Mr. Blandino lost a trial, he lost on appeal, and then he decided that he was going to take matters into his own hands. If at that point he decided to just file that complaint, fair enough, but that's not what he did. He decided to try to settle matters, he decided to threaten the judge, he decided to keep impersonating a public officer. Mr. Blandino, again, tells you that if at any point Mr. Federico said stop, I'd have stopped. He did. Mr. Federico told him to get out of the courtroom. Any reasonable person would infer from that that means stop. That means leave me alone. But no, Mr. Blandino keeps showing up. Keeps showing up where he knows that he can get some power over Mr. Federico. And, you know, Don Quixote wasn't tilting at windmills for fun. Don Quixote thought he was a knight. Don Quixote wasn't actually doing anything for himself. Mr. Blandino was. Mr. Blandino was doing things for himself, and he was doing this. What's his motive behind all this? He's doing this for fun. If you're not having fun, you're not doing it right. That's what Mr. Blandino told you a couple hours ago. Ladies and gentlemen, Mr. Blandino is not Don Quixote. Mr. Blandino's intent and motive during this entire case was to gain power, was to gain control, was to cloak himself in the authority and power of a statutory and constitutional commission in order to try to get that modicum of power over a judge who had already found him guilty. You have an instruction on credibility, and it basically says, consider everything. Consider the testimony, consider the demeanor on the stand. That's also applicable for Mr. Blandino. You've seen him throughout this entire trial. You've seen him at defense table. You've seen him on the stand. You've seen his attitude. You've seen his response to question. So you've also seen Mr. Federico. You've seen Mr. Federico, who admits he got upset, he got annoyed during proceedings. However, Mr. Blandino himself said, you know, there is a right to maintain control over a courtroom, and that's what Mr. Federico was doing on August 28, 2018. You sat through that trial twice. So you saw exactly what type of control needed to be exercised over Mr. Blandino in order to maintain the proceedings and the rule of law on August 28, 2018. You saw Mr. Federico tear up. You saw how choked up he was when he thought back on how scared he was for his family. And you saw Mr. Blandino laugh. You heard Mr. Blandino a couple hours ago tell you, well, that was pathetic. Those were crocodile tears. I was laughing because those were actor's tears. Ladies and gentlemen, I would submit to you that you should consider Mr. Blandino's statements as to that. I would submit to you that you should consider Mr. Blandino's behavior throughout Mr. Federico's testimony and throughout his own testimony. And I would submit to you that Mr. Federico was in fear. Mr. Federico suffered injury from Mr. Blandino's actions. Now, again, this is about the rule of law versus the rule of Blandino. The rule of law being that all persons, institutions, and entities are accountable to laws that are publicly enacted, equally enforced, and independently adjudicated. This is about the independence of the judiciary that is the bedrock of the rule of law. And this is a trial about, the rule of Blandino, which is basically whatever rules he say they are. When the rule of law disappears, we are ruled by the whims of men. Ladies and gentlemen, when you go back to your deliberation room, you're going to have this verdict form, and Mr. Dickerson on rebuttal will come up here and ask you to find Mr. Blandino guilty of extortion and guilty of impersonation of an officer. Show Mr. Blandino that it is not the whims of men that control, that it is the rule of law. Thank you.
Okay, at this time, we're going to take a recess. During this recess, you're not to discuss or communicate with anyone, including your fellow jurors, in any way regarding the case or its merits, either by voice, phone, email, text, internet, or other means of communication, or social media, or read, watch, or listen to any news or media accounts or commentary about the case, or do any research, such as consulting dictionaries, using the internet, or using reference materials, make any investigation, test a theory of the case, recreating aspect of the case, or in any other way investigate or learn about the case on your own, or form or express any opinion regarding the case, till it's finally submitted to you. We'll be in recess for 10 minutes. Thank you.
Thank you. All rise for action. Carry, please. Third.